Mr. Chair, we are live.
Okay, thank you. Good morning, everybody. Welcome to the February public session of the PURSUANT Commission on Public Ethics. A few housekeeping matters just to get started here. First, and most importantly, to welcome new Commissioner David McNamara. Welcome to you. Thanks for joining us.
Thank you. Appreciate that. Looking forward to meeting all of you in person.
Great. We'll all look forward to that, I'm sure. And second, of much less importance, you'll note that the acting part of the title that I've got here is now being removed. I have determined that I can and I'm willing to take on the chair on a more, I'm not going to say permanent basis, but without the acting piece in front of it. So from henceforth, it will just be chair. So with that,
where do we send the roses?
Okay, with that, agenda item number 2, approval of minutes from the public session in January, which is at attachment A in the binder. Can I have a motion, please? Thank you. Second?
Commissioner McAuliffe, seconds.
Okay, thank you. All in favor?
New York City unanimous.
Unanimous
WebEx.
Albany also.
Okay.
And Buffalo, yes?
Yes. Commissioner McNamara, can I ask you just to scoot to your left a tiny little bit so we can see you? There we go.
Sure.
Got you. Thank you very much. Okay. Item 3, report from staff.
I'll start off, Mr. Chair, with the outreach update. A few items, just to bring the commission up to date. This past February 6th, Monica and I were invited to address a small seminar of NYU Law School faculty and had a nice give and take with them on general issues involving ethics and JCOPE, and it was actually a pretty interesting experience. I'm scheduled to speak to the I think it's the committee on one of the ethics committees of the Association of the Bar of the City of New York on March 21st. I've been asked to meet with them and be open to questions, and I'll be doing that down in New York City on the 21st. In terms of other outreach, we have an ethics reminder that we do periodically that will be going out very shortly. On the rules, public employee or public officials need to know about attending conferences and the guidelines and the advisory opinions that address those. So that should be going out shortly under our Director of Ethics, Keith St. John's direction. And finally, we have an annual report that will be produced. We are in the process of putting that together. It takes a while to tabulate the lobbying, all the lobbying statistics, but that is a work in progress. And as that is getting completed, we will certainly pass drafts and get what we can out to the commissioners. So in terms of, since our last meeting, that I think brings us up to date on outreach activities that we've been conducting. Hiring update will be Monica. You would be so kind if you bring us up to date on hiring.
Sure. We just, we've had several positions posted for the past few months, and so we just wanted to update the commission that over the last few months, we filled 4 of the positions in the training unit, in the compliance unit, and in the lobbying division. We still have 2 vacancies that we're trying to fill right now, a compliance auditor and an assistant filing specialist in lobbying, which right now brings our total to 55 employees. If anyone has any questions, I'm happy to answer them.
Any questions?
I don't.
Okay. Item 4, the application of NYCLU for exemption from source of funding. That's at attachment B.
Monica, if you'll handle, this is an action item for the commission to vote on what motion on whether to grant the application. So Monica, you want to kick it off, you and Andrew?
Sure, just so that we received an application from the NYCLU on January 16th, and it covers the period from July through December of 2017. So they're applying for an exemption for all of its sources of funding pursuant to 19 NYCRR Part 938.4B. And as the Executive Director stated, the motion before the Commission is whether to grant the application. With that being said, I'll just remind the Commission that you need to establish a record for however you're going to vote. If the Commission does not carry a vote to grant an exemption, then a letter will be sent to the NYCLU, including a statement of findings and conclusions and the reasons for the basis for the denial. So again, it's important to create a record and state the reasons for your vote. With that being said, I'm going to turn it over to our Director of Lobbying, Andrew Bouchard, to discuss the standard before the Commission and the materials in the application.
So as Monica stated, the agenda matters to have the Commission render a decision and make a record on the New York Civil Liberties Union's request for an exemption from source of funding disclosure requirements under the Lobbying Act, Section 1J. NYCLU provides evidence, several documents from this past year containing what they describe as hostile correspondence. It includes 13 holiday cards, 1 birthday card, 1 postcard, 12 letters, and 4 assorted photos or posters, which include statements such as, "May this be the year you go out of business. You're a disgrace to America. Hoping you will be gone. Hoping soon you will be gone." The NYCLU application further relates that during the past year, an ACLU employee was the target of harassment and death threats on social media, and offers further details on 10 other incidents of hostility at other state affiliates other than NYCLU. And the legal arguments that are made are the same as in prior applications, and the application goes into quite a bit of detail about the ACLU employees who were the targets of harassment and the other incidents of hostility at the other state affiliates around the nation. So I'd be happy to try to answer any questions that you might have.
And we'll try to keep an eye on, there are a number of commissioners who are appearing by WebEx and otherwise, so we'll try to see if we can, I don't know what you can see, Mr. Chair, on commissioners who might want to be recognized on the subject.
Yeah, I mean, I can see everybody, so
Good.
if people just put up their hands, we can get through it all. Monica, you want to say something?
Yeah, I was going to remind the commissioners that for a 501c4 organization, the issues are they can show that their primary activities involve areas of public concern that create a substantial likelihood that disclosure of its sources will cause harm, threats, harassment, or reprisal to the sources or individuals or property affiliated with the sources. Factors the Commission will consider when determining whether the showing has been made include, but are not limited to, factors that are identified in our regulations. And there are 5 in our regulation, which I think the Commission has before them. If anyone has questions about those, Andrew or I can address them.
Commissioner Yates has his hand up, Chair. I just can see
Commissioner,
that.
go ahead.
Yeah, I don't want to blindside anyone, so I want to tell you what the procedure here is for me. As you know, I've recused myself on this matter, and I'll continue to recuse myself. So I'm not going to say anything at this time. And I haven't participated in the prior discussions that may have occurred on this as well. However, as to the generic issue, as to what the law says and how it should be interpreted, I would like to be heard after the vote. So, as I said, I'm not going to participate now. I'll continue to recuse myself, but I would like to be heard after the vote is taken, if I can, not on this application, but just on the general standard and whether or not and how we should, whether we're following the law and how we should follow the law.
Okay, thank you, Commissioner. We'll definitely hear your comments afterward. George?
Yeah, good morning. Thank you very much. Quickly, as I understand the statute, the concern that should be before us is the effect on the NYCLU of any of these harassments, these complaints, whatever's been submitted to us. We've seen a lot of the past information, but with the new information we've received, it seems that most of this, they use the term state affiliate, which at least to me indicates that it was not directed at the NYCLU. So I'm not sure of the probative value of looking at information that doesn't directly affect NYCLU. And I'd like to add that when we're looking at this question of donors, I don't think there was anything relating to the donors in particular in terms of harassment. And finally, everybody comes to New York State to raise money, all sides of the political spectrum. And I'm reasonable, I can't say I'm reasonably sure, but with everybody coming to New York to raise money, it seems to be a place that is open-minded, at least, to all parts of the political spectrum. So in that regard, I'm not sure how this would really affect the NYCLU. Thank you.
Others? Okay.
Can I?
Yes, go ahead, for sure.
I'm going to the footnote on page 1 of their application. They make a distinction about kind of a long-term exemption versus an exemption just for this reporting period. Is that relevant at all in terms of differing standards, or is it the same burden and the same standard?
No, I mean, they make arguments in their application. First of all, they make legal arguments that they've made about the way we're interpreting the law. Among other arguments that they make is that it's not meant to be an exemption that is considered based on the past 6 months of time, that it's supposed to be looking back at the nature of the organization and the types of threats and harassments that they have faced generally, and that the organization itself would be granted an exemption, end of story, and that it wouldn't turn on the last 6 months. So that's their argument, is that they think that the way the statute reads is that they're just because of who they are and what they do, they're entitled to an exemption, and that the analysis way we've interpreted the statute and the analysis that we go through is not in accordance with the statute. They make other legal arguments as well about how we interpret our regulations. I will just make one point to some of what Commissioner Weissman said. I just want to remind the commissioners that one of the factors that the commission will consider is evidence of harm, threats, harassments, or reprisals directed against organizations or individuals holding views similar to those of the sources or client filer. So evidence related to state affiliates is certainly something the commission can consider. You can give it whatever weight you deem appropriate.
What were you just referencing there, Monica? What?
The commission's source of funding regulations. Mm-hmm. There are 5 factors that are not exclusive, but 5 factors the commission will consider in making its determination. I'm happy to read all 5 if the commission wants.
No, you were referencing 938.4A sub 1 just then, correct?
Yes.
Okay, thank you. I was just wondering which of the subdivisions. Thank you.
I'm just double checking right.
Mr. Chairman, I'd appreciate it if the General Counsel would read all the factors.
Okay, I'm just double checking that. Yeah. Okay. Specific evidence, and again, it is in 938.4A lists the factors. So those are our regulations. Specific evidence of past or present harm, threats, harassment, or reprisals to the sources or client filer or individuals or property affiliated with the sources or client filer. The severity, number of incidents, and duration of past or present harm, threats, harassment, or reprisals of the sources or client filer or individuals or property affiliated with the sources or client filer. Number 3, a pattern of threats or manifestations of public hostility against the sources or client filer or individuals or property affiliated with the sources or client filer. Evidence of harm, threats, harassments, or reprisals directed against organizations or individuals holding views similar to those of the sources or client filer. That's number 4, which I read a few minutes ago. And 5, the impact of disclosure on the ability of the sources or client filer to maintain ordinary business operations and the extent of resulting economic harm.
And this is a non-exclusive, this is a list, this is a it's these factors are included, but there could be others as well, so it's a non-exclusive list. So.
Any other commissioners want to be heard on this? Okay, well, in the absence of any further comment, I guess we have to take up two separate votes here. I guess one is to whether or not we grant an exemption, and if so, then are we granting it on a more long-term basis or just for the recent reporting period from July through December? Commissioner Small's reference in footnote 1 of the application.
Yes, we need a motion.
Yeah, so can I have a motion, please? Somebody?
This is a request for a 6-month exemption. Is it just to make it?
Well, it's 2, actually. It's a request for either or, a 6-month exemption or for a longer-term exemption if we should see fit.
So the first motion is just a motion to grant an exemption, and then if it's granted, the second motion would be to decide on a period of time. Does that make sense?
Yes.
Okay. We need a second. So.
Commissioner Smalls, you're moving for an exemption?
I am
to
moving
grant?
to grant an exemption.
Okay. Do we have a second? Okay, second. Thank you. All in favor of granting an exemption?
New York City, unanimous.
We have Commissioners McAuliffe and Deering in the affirmative from Albany.
Sample.
And Barry, right?
And I think those are the 5 votes.
Buffalo? Anybody in Buffalo?
Buffalo, no, I see no one in Buffalo, and I see Commissioner Sample. I don't see anyone else in the affirmative.
All opposed? Can I see hands just for all opposed, just to make sure that we have that precisely? Gary, we can't see any hands of yours. Thank you. 1, 2, 3.
I'm missing somebody.
4, 5.
Is anyone in Albany?
Well, Commissioner Yates is recused.
Oh, right. Okay.
Okay. All right, so the motion does not carry.
Is it 5 to 5?
It's 6 to 5.
6 to 5.
Commissioner Yates is recused.
Yeah.
Right.
There are 12 of us here.
Oh.
Okay.
Mr. Chairman, on the motion, if I may.
Please.
I continue to be of the view, if I may express it for emphasis, substantial likelihood of harm, in my view, means more likely than not to ensue. And the record before us does not demonstrate that to be the case. Thank you.
Commissioner, can I ask you one question? Would you also suggest that the record wouldn't even satisfy a lower standard?
Well, the standard that informs my decision is more likely than not to occur. They have not met that standard, in my view.
Commissioner Weissman has his asked.
Yeah, go ahead.
In response to the executive director's question, I do not believe it meets any evidentiary standard under the circumstances. So I concur with that statement.
Commissioner Yates, to come back to you.
Is there a second vote to occur yet, or I thought you said 2 votes?
We don't need a second vote.
Okay.
We don't need a second vote because the motion didn't carry at all in the first instance.
Okay. So at this point, we're no longer talking about NYCLU. We're just talking about matters in general.
Correct.
Okay. Based on the public record, and not looking at the NYCLU case, but just with regard to questions that have arisen in the past by various people in the interested community, there are 2 issues that I'd like to raise. Number 1, there seems to be some question or confusion over whether or not proof of harm or threats of harm to an organization or its employees in and of itself is insufficient unless there's also proof of a history of threats or harm to the donors. Because remembering that the issue here is that we're keeping, if we grant a privacy request, we're granting a privacy request to members and donors. I think that's wrong. If you look at the history that led up to the statute, if you look at NAACP versus Button, NAACP versus Alabama, Buckley versus Vallejo, you see that the need for privacy and the interest that was to be protected arose not out of a concern of whether or not a donor would be injured or whether or not a donor would be hurt. It arose out of a protection for the First Amendment right to a freedom of association. And the issue was whether or not privacy was needed to protect against chill or even a bar to the ability of people to associate in membership, whether or not they could get together and express their ideas. When the statute was written, I know for a fact personally that case law arose and was discussed, and that was the genesis of the statute. So that to the extent that anybody feels, well, let me just follow up with one thought. If there's a threat to an organization, then that is a reason why people will not become members if they know their names and identity are going to be disclosed. If you know that a theater is going to be bombed or a restaurant's going to be bombed because of threats, then you don't want people putting out on a list the fact that you're a frequent customer of that restaurant. And so what needs to be protected here or looked at is not whether or not there's been a particular threat to a donor, but whether or not threats to the organization in and of itself dampens the ability of people to join and restricts people from joining, and whether disclosure of their names or the threat of a disclosure of their identity will keep them from effectively joining the organization or donating to it. And now the regulations in and of themselves do talk about a recognition that we have to look at the harm to an organization, and that's good. I'm not complaining about the regulations. I'm just trying to resolve an open public discussion the issue of whether or not we should look beyond the simple question of whether or not there's been a threat to a donor and look at the larger question and see whether there's been a chill to the freedom of association and the ability for a controversial organization to function. That's number one. Number two, and I won't belabor this much, and actually I wasn't going to say anything about it, but Commissioner Levine raised it, so I'll respond, and that's this. The Supreme Court case law talks about the standard being a reasonable probability. Our regulations call for a substantial likelihood. I'm okay with our regulations, and I'm not asking for them to be changed as long as there's a recognition of the constitutional standard. I think to the extent that that commissioners in voting would impose a higher standard than reasonable probability explicitly, they endanger the validity of a determination by this commission.
Thank you.
May I, Mr. Chairman?
Please.
As usual from His Honor, very cogent comments. However, I do not accept the tacit underlying premise that the vote, at least my vote, has been based upon parsing out various elements of the deliberation. Impact on donors is one factor. Threats against the staff or the property of the entity are another factor. The Supreme Court holdings, of course, are a factor. My view is that we should approach these applications with an evaluation based upon the totality of the facts presented to us, the circumstances and the law as we understand it. I repeat in a slightly different form what I stated several minutes ago. Substantial likelihood of harm or reasonable probability, either one, in my view, means in practical application more likely than not to occur. And this record presented to us and all the other circumstances to be considered do not make the case that compels the conclusion they should be exempt, particularly given the transcendent purpose of the statute, which is to divulge the source of funding.
Thank you, Commissioner. Anybody else want to be heard on this? For what it's worth. Oh, Commissioner Jacob, I'm sorry. Go ahead, please.
I just wanted to address Commissioner Yates's point about his experience with this legislation. And I think that just confronts the problem we've had before, and that is the statute refers to donors, sources of funding. It does not refer to organizations. I don't think we can regulate by writing regulations that conflict with the statute, nor can we talk about our personal experiences with a statute and alter its plain language or meaning. And whether you vote for this or you vote against it, I think we're bound to what the statutory language is, whether the regulation says one thing or another, but we're certainly bound to it in terms of what our personal experiences are, whether they conflict or not with the statute.
Thank you, Commissioner. Anybody else? All right, let me conclude this piece by adding, for what it's worth, the motion didn't carry, so it's irrelevant. But my vote to grant the exemption would have been for only the past 6 months in order to allow us to, in light of what I think is new evidence, a lot of it is a rehash from the last time, but some new evidence here that would have allowed us to give yet further consideration to an issue that we have all debated ourselves a number of times. What is the appropriate standard? And one or more commissioners have suggested in the past, without trying to put words in their mouth, that the standard, they believe that the standard that we've set is unattainable, which is also a criticism raised in NYCLU's application this time. So it's irrelevant for the moment because the motion didn't carry, but I suspect that we're going to be having this discussion again since they seem to be quite persistent in making application. I would expect that we're going to receive another one shortly, so we'll have an opportunity to debate it again, but in the fullness of time. All right, next item 5 on the agenda, new and other business. Any? Do we have any? Seth?
Nothing from the Albany office.
Okay. That then concludes the public session of the February meeting. I need a motion, please, to enter into executive session.
So moved.
Commissioner McAuliffe is
Commissioner, second. Second.
Commissioner Yates is second.
Commissioner, all in favor?
New York City.
Buffalo, Albany as well, and our various. We're all there.
Okay. It's unanimous. Thank you. We are concluded.
Stand by.
We're back in public session.
Okay, thank you. Monica?
Sure. In executive session, the commission authorized steps in several investigative matters and discussed several investigative matters and received updates. The commission also wanted to announce that it is looking for candidates to serve as hearing officers. We have a pool of hearing officers that are randomly selected to sit on our hearings when we have matters that go to hearing. And if anyone is interested or knows of anyone that's interested, please call Jay Cope and let us know, and ask for the general counsel, and I'll speak to you.
Okay, thank you. Can I have a motion, please, to adjourn the public meeting? Thank you. So moved. Second. Thank you, thank you, thank you. All in favor?
Unanimous in Albany.
Who made the motion, Monica?
Commissioner Smalls.
Who seconded?
Seconded was McAuliffe.
Okay.
Thank
All right.
you.
Okay, it's unanimous. We are adjourned. See everybody next month. Thank you.
Have a good week.